Today for class, we're going to talk over some legal issues. If you've had me in class before, you may have discussed these items, but please make sure that you review this PowerPoint in order to understand what is going to be on the exam next week. So, for legal agreements, we want to keep in mind that these come up from time to time, and especially if you are a freelancer. So I wanted to cover some of these because these are important for you. So why do you really need to understand these two agreements that we're going to talk about? Number one, you're very likely to have to sign these. So if you get hired as a freelancer, in almost all instances, you're going to have to sign some legal and tax documents. These documents impact your rights. Intellectual property refers to things that you create, whether it's media or you contribute to a project with your own creative ideas. All of that comes under your intellectual property rights. And many of these agreements ask you to relinquish or waive those rights. And that is not a big deal. That's very common. You don't have to feel like you're getting taken advantage of, but you do need to understand that that's what's happening. You really want to make sure that when you are going into a project, you understand whether you have a vested interest in the creative rights or whether you are being paid to produce something for someone else. Secondarily, if you hire someone, you are likely going to ask them to sign these rights. So that means if you are producing something, or if you're a drone operator and you decide to hire another drone operator that's going to work with you, or if you're doing weddings and you ask someone else to help or to do some additional photographs, you are actually probably going to want them to sign a work for hire agreement so that you maintain the rights of your project. If you are hired by someone and you are a freelancer, anybody that you hire will also be bound by those agreements. So even if you don't go through the process of having them sign one for you, although you should, they are still going to be bound by that agreement that you sign. So that's the understanding. So let's look at these two agreements. The first one is a work for hire agreement, or WFH, sometimes as an abbreviation. So this has to do with several different aspects. And so these elements are all contained within a work for hire agreement. First of all, it demonstrates that you are working as an independent contractor and not an employee. We talked about that in terms of being an independent contractor or a freelancer, and that has certain ramifications for your tax status and your independent status when it comes to the IRS. So one of the things in a work for hire agreement is that you're an independent contractor. You are not an employee. And consequently, they're not going to deduct any taxes from your payments. And they'll also usually ask you to sign a W-9. Now, in addition, one of the biggest aspects of a work for hire is that you are waiving your rights to ownership of the media created. You are essentially saying, yes, I contributed to this. Maybe I added some elements, I added creative input, but this is not being owned by me. I am relinquishing those rights. And so that means that it is owned by whoever is the other party in this agreement. So that could be a producer, or it could be a production company, or it could be the end user, the client. So any one of them may be having you sign this agreement, and you are granting those rights to them. So that means if you're a freelance drone operator or camera operator and you get hired by a production company, you sign a work for hire, you are giving them the rights to use this media, and you don't have any right to come back and say, well, wait a minute, I didn't know you were going to use it in this way, or I thought you were going to only uh, use parts of it. You can't do that. You are signing away all of the media that you work on. And lastly, this is kind of related, but those are distribution rights. So that means that what you're getting paid for is your total payment. They are not owing you anything else if they decide to use it in a different way. So someone might hire you to shoot on a TV show, and you work on it either as a PA or a camera operator, and then they end up distributing those rights overseas. Or maybe they take the media and they edit it into another program. Or maybe they take that media and they actually sell it as stock media. Let's say you shoot some car video and they end up taking it and putting it in a commercial, but then they end up selling it as stock media for somebody that wants shots of a car. You don't have the right to go back and ask for more money or tell them that, oh, hey, you only agreed to use it for this purpose. They are essentially having you sign away or waive those rights, and you're not entitled to any additional compensation unless that is spelled out in the agreement. Okay, now a non disclosure agreement or an NDA is another common agreement that you have to sign, and these are very, very common on most shoots. What this is talking about is that you are probably going to encounter some confidential client information. So we'll look at some examples in a minute, but this could be provided verbally or in written form. So they may talk about something in a meeting. That's verbally. You are overhearing that information, and then they may provide you with notes or documents that explain what it is that they're going to do. It may be in terms of a storyboard or a script. So all of this is confidential information that is a part of the project. And when you sign a non disclosure agreement, you are saying, I am going to keep this information confidential. Now, it may be communicated directly or indirectly. And what I mean by that is they may be talking to you directly and say, hey, here's some information about some of our plans, or here's what we're doing. But you may also just overhear it. So you might be on set and you might hear somebody talking. Maybe the director or the producer is talking to the client. You may overhear some of their information. That is still confidential. So while you are in that relationship, all of that information is confidential. So some examples, and this is not exhaustive, but they may communicate business plans or strategies. For example, if you're working with a commercial client, McDonald's might say, hey, we're going to expand into a new market, or maybe there's a regional entity like Chick-fil-A, and they've never been overseas, and they're going to open up stores in Japan. And so that's confidential information. Those are business plans, things that they plan to do. You may also be exposed to budgets. That could be for the project you're working on, or it could be financial information about sales. They may have customer data. These are our typical customers, and here's who we're targeting, who they're marketing to. Also, products. So you may be working with a company that has products, maybe a car company that's coming out with a revolutionary new engine, or a product that's going to revolutionize cell phones, or software. So anything that's product related is confidential. When you're doing with entertainment, it could be scripts. Could be the results of a program like Love Island or Survivor, where somebody is going to win a prize and they're doing 20 episodes of that program. You cannot reveal who the winner is or who got voted out last week, or somebody that got kicked off the show. Also could extend to who's involved in a project, who's the director, if something is in development, or who are actors that are going to be in a movie that hasn't been produced. So this is all confidential information. So how do we decide if something is confidential? It's any information that is not publicly known. So that means if something is revealed to you, you should assume that it is confidential. You never want to make the mistake of revealing something and then saying, oh, I thought that was known, or I didn't think that was confidential. That doesn't matter. You're going to be held responsible. So the only time you would want to reveal something or talk about something is if you like read an article or you see a news report where this information is available. For example, if you were talking about Chick-fil-A expanding and you saw an article or a news story on TV where they talked about Chick-fil-A expanding into Japan, then, oh, okay, well, you don't have to worry about it. But generally, be very, very cautious about revealing something that is not known. Additionally, you may be provided with confidential information. So that could be a recording of a meeting with a client. It could be marketing materials that they're going to use. It could be storyboards. It could be copies of script. So if you actually have that in your possession, you are agreeing to keep that confidential. So that means if you go back to your office, you're going to keep those things filed away. You're not going to leave them out on your desk where somebody could possibly look at them. You're not going to leave them laying around in a car where your friend can pick them up and read them. So the confidential information, you are going to keep those items secure. At the end of the project, you also usually agree to give those items back to the client. So that means you no longer have access to them, but they are still confidential. And lastly, when it comes to non-disclosure agreements, there are incredibly severe penalties for violating NDAs. So that means if you reveal that somebody won Survivor or Love Island and it essentially messes up the climax of the show, then you could be facing millions of dollars in penalties. Obviously, you may not have millions of dollars, but that means that you're probably going to be held responsible for large amounts of money, and they'll pretty much take everything that you own and financially maybe garnish your wages. So it could be very, very severe. Even if it's not something like that, if you imagine a large company where a competitor could take advantage of something that is marketing related, you cannot violate that. They are going to hold you responsible, and it's going to be very, very costly. So those are the important agreements that I wanted you to know about. This information will be on the final exam, so make sure that you review this PowerPoint and study this information so that you can answer questions. Finally, kind of as a summary, keep in mind that these agreements are important because you either will be agreeing to them as a freelancer or you will be making other people agree to them. So they will be held to the same standards. Okay, that is all I have for class today.